Timor system, yeah. I'm not using Timor system because I was not sure that it's widely known. So, like Feldman system, it's much close to Western terminology, but of course it is Timor system. It is precise,
which is so much different from the field.
I agree completely.
Nothing in common. So
yeah, I agree. I agree with that.
So, and one more less minor comment. Well, we have remnants, that was the term, of Ottoman law in almost all the successor states of the Ottoman Empire. And I think that it is no coincidence that it is most evident in the field of land law.
No.
Because the immediate problem, think about a moment when a new state emerges. You have the immediate problem is land, because you have conflicting claims about land. And of course, the major claimant now is the state itself. And then where would you look at? I mean, the most accessible law is the Ottoman law, only for the reason that it already had gone through the process of, modern Ottoman law represents the logics of the centralizing state. Right, so even if we are talking about the Timar system, so it's the 19th century, so it's not the 16th century Timar system, right? So I think that you have here, I mean, it's a fascinating case and it's an important job, but I think you really need to put it in, at least to think about it, to put it in a comparative perspective. Because you have all these very phenomenon happening in the Arab provinces, in the Balkans, and in Turkey itself, which was not the Ottoman Empire. Right? And you have this, and there is also a fascinating question of you have this attempt to reinvent the nation, to negate the Ottoman past, and then again, you have no choice. You have to use this law, which goes against, again, the logics of negation. What do you do with the law, which is sophisticated enough, the Ottoman law, to endure? And it endured until, I think, almost today, it endured this way or another in every legal system of the successor state.
Yeah, I agree completely. Thank you.
Other questions or comments? Yes?
Well, my question is to Paola. Well, maybe it would be best to ask Jewish colleagues about it, but still the question is to you. Well, I just don't know to what extent did the Jewish religious legal system influence Israeli law?
Of course, in the family law, because I didn't say that the part of family law is outside the code and is regulated according to the different religious beliefs. So there is a tribunal, different tribunals, and also in Israel there is not a civil marriage, and so there is a strong presence of religion law in this strip of land.
Is there influence of Jewish law on the code itself?
Yes, there are parts in which there are also in terminology where there is the influence of Jewish law. I didn't focus on it. But yes, there are still parts, and there was a part at the beginning of this, when they started to talk about what to do with the private law in Israel. There was a group of people that said, okay, we can stay connected to the common law. Another group of people that said, no, it's Israeli law, it's Israeli private law. So we have to rely upon the Jewish law. And there was another group that said, no, it's better that we do this comparative law, taking inspiration from the law of the other country. But there was a group, but there was also the problem that maybe Jewish law could be too obsolete or too difficult to become the private law that is so close to reality, so close to the problem of everyday life.
Thank you.
Any more questions?
Yeah, I have a question for Liliana.
Yep.
very interesting and compelling, your presentation. I was wondering, I mean, if I think about the way of codifying law in Austria previously, in the Codex Teresianus in the 18th century, it's a recent attempt to have a code. They tried to solicit reports by provincial commissions, for instance, to retain certain local customary figures like certain rules for Remisio Mercedes or Lesio Enormis or whatever. So the question is, how did the commission work in Serbia? That's my interesting question. And how did these choices that you actually referred to happen? Why were those institutes deemed worthy of being retained in comparison to others? And what kind of power bargains and interest groups were making themselves felt in this kind of commission? That would give some flesh on the bones.
Thank you for the question. The commission itself was changed for several times, but we had one enquete among the common people, and they should have answered specific questions. And what is the custom with legal transfer of land? What is the custom in specific areas? And that enquete, it's preserved in Archive of Serbia. I read it, and the custom was, in the specific case, for instance, of Tapus, the custom was to transfer the Tapu document on another person. But then I would not say that they look completely on these results of these enquetes in making the civil code itself. And but in some fields, especially in family law, you have custom law, not Austrian law or not remnants of Ottoman law, because of the, as Paula mentioned it, millet system in Ottoman Empire. So there are certainly traces, but in the field of property law, as also colleague said, this is the strongest influence of Ottoman law.
No more questions? One more?
One comment to Ilya and Paula's conversation, and then one question to say. One is that it has a very actuality, this conversation on the Jewish religion and Israeli law. If I'm not mistaken, there is a basic law proposal which is not yet reached the vote in the Knesset, submitted by Avi Dichter. In the section 13 it says, where a court decides that the dispute cannot be resolved by existing statute, by judicial precedent, or by strict legal analogy, it shall render its decision in accordance with the principles of freedom, justice, equity, and peace derived from Jewish civil law. And that is Mishpat Ivri, which is very controversial, and no one knows what this basic law means by that. But if this basic law is accepted, it will give a very strong position for the Jewish legal tradition in the Israeli legal system.
Yes. And also I wanted to say that at the beginning of 1948, the Zionist movement was really against the coercion of the religious law. This was one also of the reasons why there was not taken in consideration to build a private law based on the religious Jewish law. This is another thing, yeah. But there is also this balance that we have to find between, I think, according to what I saw, because I'm not Israeli, and when I came here, I started asking people about the code and everything, and there's also always this looking for balance between religious group and liberalism, socialism, court power, and it's part of the fascinating thing of Israel.
Can I have a question to Hesse? I was fascinated by von Bunge's draft and the articles, especially the structure. That in the typeface, it has a definition, a rule, a reference, and then Anmerkungen. Mm-hmm. Was it his invention, or was it based on some previous works? and how the articles within the 4,600 relate to each other. Was it an architectonic system, or just articles one after each other in no order?
There was the rule that there should be references to the sources. So the references part was obligatory, actually, according to the order that Nicholas first gave. Then the Anmerkungen was Bunger's own invention, because he wanted to add something that was also in the provincial law, but he didn't want to put it in another new article because it was too much. So this was to have some addition. But then the system was there. As I mentioned, there was family law, the property law, the Sachenrecht, law of succession, and then, yes, and this was according to the institutes, for example, Kaufkontracts, etc.
Question to Hesse. Could you clarify, please, what does this, what you just say, I can pronounce this, whatever, is it an interpretation of an article?
No, it is just an addition to an article. It's a remark.
Because I know the tradition coming from the in Codex Theodosianus, there was in every article was followed by the sort of authentic interpretation of itself.
No.
And I know in Russian early 18th century Peter the Great's legislation, which in turn imported some style from the German and Swedish legislation, it also contains interpretations in
No, it was some addition to the regulations article. And it was usually, for example, this is not valid for the provinces of Kurland, or this is different in the provinces there.
And a more general question to you. So, to what respect those developments in the 19th century, maybe not developments, those legal consolidations of the 19th century were used after 1918?
Yes, they were valid after 1918. The new republics of Estonia and Latvia continued with the Baltic Private Law Act, but there was abolition of estates. So the articles concerning some specialities for estates were in principle not valid. It depended on the court which one they applied or which one they didn't applied or not.
Estates, you mean social groups?
Yes, the nobility and clerks. It was for all the people, peasants and everybody. This was their private law. And in Estonian territory, it was until 1944 all valid. Although in 1991. After Estonia regained its independence, it was a question whether to put into force the Baltic Private Law Act. And fortunately, it was not done so, because it has very strong particularities also in territorial levels. And this would be impossible to follow at the moment.
That's all the questions. I have some questions as well. Let's start with Miliana. It comes with a little background. As you know, our French neighbors or friends visited us in Belgium at the end of the 18th century, and they brought with them their laws and their codes, their imperial decrees, and that effectively abolished what we had in Belgium, our system, our laws, and we never really looked back. There have been commissions that research it, but not as an instrument or inspiration for new laws. And that brings me to my question for Miliana. You talked about the connection between the Ottoman law and the law in the 19th century in Serbia, but what about the pre-Ottoman heritage? Are there references
Yeah.
about that?
Well, that's a very interesting topic actually, because Serbia in pre-Ottoman time had developed law, and is the most famous is Dušan's Code from 14th century, and after Ottomans conquered this territory, the law was not in force anymore. But then, when the Serbian nation starts to build up the state, there are some testimonies that they were looking at this pre-Ottoman Serbian law, and that in all these cases with this Serbian Civil Code came in 1844, but before there were also some different legal acts, not very developed legal technique or so on, but they were trying to make legal rules for different situations, and they were looking at this law, pre-Ottoman law. But that law is also, the interesting thing is that law also rely on Byzantine law partly. So we could say that there were some traces of pre-Ottoman Serbian law, even if it's really like an extended interpretation of building the law itself, national law of Serbia. Thank you.
But you had customary law, Byzantine customary law in the Kanun, in the dynastic law, right?
Oh, yeah.
Quite a good deal of it, right? So.
Oh, that's extremely interesting. Yeah, of course.
I had a question for Hessie also, but this was more or less answered. I have another question. You talked about the drafts in the second part of
Yes.
the 19th century. I was wondering if there are a lot of references to international journals at that point, because at the second part of the 19th century you get a lot of international organizations, they publish in international journals, and they compare legislation. They have people reporting on the legislation in their country, so they bring together that information. And if you look at the Belgian codes or drafts in that period of time, you see that there is a lot of references to those organizations or published works. Have you seen anything like that?
No, I haven't seen. I do know that after Public Private Law Act was enacted, there was some, for example, in French, a book about new legislation in Russia. But actually, the draft of Himmelsterne was in handwriting. So this almost excludes the larger commentaries. And no, I haven't heard anything of it.
Okay. That's an answer to my question. I have two more small questions. Paula, that's right.
Yeah.
You talked about the comparative law research in the 1960s.
Yeah,
Right.
started.
There were several countries, and the dominant one in that was Germany.
Yeah.
What were the other countries, and do you see differences in that? Were there, for instance, France, was that an important one? And two, what criteria were used to actually select the countries? Was it the scientific tradition of that country? Was there a language barrier in choosing?
No, I think it was predominantly German, French law, Swiss law, and it was connected to the founding fathers, so to these jurists that started to create the Israeli law. So they came from that part of the world, and so they just brought the law that they knew, and there was predominantly was German law. In fact, also in the central position of good faith, the general part that they have in the code, it is really German. And there was a committee they were working together in order to find the best solutions possible for all the topics. So it was like we tried to find what is the best solution, comparing all the law. I don't know exactly what was the scientific procedure, but the aim was to find the best solution for all the problem. And it's really strange that a lot was based on German law.
So there's a lot of coincidence in there.
Yes, the same thing happened with soccer, but it's another story.
Do you have a remark?
Yes.
Of a question?
I'm guessing you refer to the Harvard project.
Yes.
So it began in the 1950s, and the collaboration was with Harvard University in the United States, not with the European universities. But I do agree that they turned to many European legal systems to compare and see how specific laws are there. The criteria for choosing on which areas to focus was this, this patchwork. I mean, it was evidence law and inheritance law and the family law that were patches of Ottoman law and British law and a little Jewish law and religious law, and they tried to do this codification. I think that none of the drafts that were made during this project was none of them became a bill as is. But it was these were the basis for many bills that came afterwards. I mean, the guardianship law is based on a part of the family and the individual bill that was prepared by this committee. The property relations between spouses law is another example. The inheritance law in part is another example. So it was very influential, but it was not. I mean, it's not that they took this German law and then transplanted it to Israel.
No. It
Just,
was not a transfusion. No. It was not a transplant. Yes. Not a transplant at all.
Exactly.
Thank you for your interesting remark. We have time for one more question for Terence. You talked about Baden now, and you explained that they had an experiment with 3 villages, and then they expanded that, if I understood that correctly.